Next case is Ace American Insurance versus Besco. Ms. Wilder.
Good morning. May it please the Court. Rosemary Wilder, representing Ace, the appellant. I would like to try and reserve 5 minutes for rebuttal. We'll see how close we get to that. This is a very unusual case because the appellee is asking you to create brand new bad faith law in a case where bad faith was never pled, and they admit that in their brief. What happened in this situation was that a turbine encountered some problems in the Dominican Republic, and the owner of the turbine, EGE, sent it to Besco in Jacksonville to have it fixed. They repaired the turbine, which they did. There's been a long-standing relationship between the companies, and EGE is one of Besco's best customers. They send the turbine back to the Dominican Republic, and a company called HSE installs it. Apparently, there was some problem with the alignment of the turbine, and when they started it up at the end of 2002, there was a problem, and it shut down.
Let me try to cut us right to the chase here. Isn't there competent, substantial evidence in the record to support the trial court's finding that ACE breached its duty to defend by taking this wait-and-see approach and just leaving the insurer to defend for himself?
No. Respectfully, what happened in this case, even if we accept every fact found in the order signed by the judge, drafted by the plaintiff's attorney, even if we take all of that, the answer is unequivocally no. What happened in this case is that they notified ACE in December of 2002, the end of December 2002, of a potential claim against them related to the installation of the turbine and perhaps some faulty workmanship. That claim, at that time, was a potential claim for loss of use for the time the turbine was down and being repaired after it had been installed. ACE immediately hired an qualified independent adjuster who was familiar with issues regarding turbines, turbine repair, etc. And he immediately went with one of Besco's engineers to the Dominican Republic, and the investigation began. In January, just I think two and a half weeks after they received first notice of a potential claim, they issued 2 reservation of rights letters. Those reservation of rights letters didn't give anybody a false sense of security because they expressly said, this is a CGL policy. So they cited the business risk exclusion. We're not going to pay for your faulty workmanship. Everybody knows how that works. We're not going to pay for your warranties. That's not what this is. This is a liability policy. We will pay for damages you are legally obligated to pay due to covered property damage. That is our insuring agreement. We have a right and duty to defend you in a suit, and suit is defined as a civil proceeding, and we may investigate a claim. Now, the issue here is that we received notice of this unnoticed, unauthorized settlement, which was the result of a business meeting.
What about Mr. Esco's apparent decision not to attend that business meeting and his recommendation that your client do nothing?
He was not invited to that meeting. Nobody ever hinted. As a matter of fact, Campagna...
Isn't there ever evidence in the record, though, that he and your client were well aware that that meeting was going to take place and what the subject matter would be?
The subject matter, absolutely. And this was the subject matter. The subject matter of the meeting was that all 4 engineers for Besco, including one of the world's leading experts in turbines, had determined Besco had done nothing wrong, and it was the HSE installation of the turbine that was the problem. ISCO speaks to Campagna, and he says, we're going down, we're going to have a meeting with EGE because we absolutely know we have done nothing wrong, and we're going to go down there and get paid for our repairs. Also something important, they did repairs to the turbine related to the installation issue. They also did a bunch of other repairs for other things unrelated to the turbine issue. That's important because that $271,000 that they eventually waived, as the accounts included both kinds of damages, and this was all presented at trial.
Here's where I'm struggling. If I were sitting in the trial judge's seat I probably might agree with you that it's pretty apparent what happened here is they tried to appease their best customer by writing off some accounts receivable and not getting paid for this additional work they did. But, you know, the trial judge whose findings we have to accept if there's any evidence at all to support them appears to me to have viewed this wait and see approach, as I think he called it, as a waiver of the, or a breach of the duty to defend.
Right.
And tell me why that would not be competent substantial evidence.
There's a bunch of problems with that wait and see. The wait and see was from an internal letter written by the adjuster to the company, which Besco knew nothing about. And what it said was, this is on March 4th. You have to remember, this whole thing took place in 86 days. It was 60 days from the reservation of rights to the unauthorized settlement. So we're talking about a huge turbine, all kinds of issues. We're communicating with Besco all along, and there's no allegation that we were not. We absolutely were. We have our investigation. We're talking to the engineers. They're doing all of their stuff. The wait and see was a March 4th letter which said, I recommend an independent expert be hired. Now, this would be the 5th expert to examine the turbine. The wait and see came from the fact that you can't look at the turbine on March 4th. You can't do anything because all we now have is the photographs because the turbine is up and running. So there's no reason to go hire now a 5th expert when you've got one of the world's leading experts have already examined the turbine before, during, and after startup. He was there on the scene in the Dominican Republic. So that's where this wait and see business came from, because what he said was there's no sense in hiring this expert now, March 4th, because there's going to be a meeting in the Dominican Republic, because Besco is absolutely crystal clear they have done nothing wrong, and they're simply going to go down there and get paid for their repair work, and they're going to resolve the claim.
Well, isn't the fact that Ace Adjuster, and I don't remember his name right off the top of my head, Isco, didn't follow up, didn't call, didn't find out what happened in that meeting, and essentially closed the file after the fact, isn't that an indicia that they
No, because the problem here, respectfully, the problem here was the settlement. Once the case was settled, there wasn't anything left to do. They settled. They entered the unauthorized settlement.
As I understood it, your client didn't have any knowledge of that settlement for a year.
No, we were told we're going down to resolve this. We're going down to resolve this issue, and we're going to get paid. As far as we knew, that's exactly what was going to happen, and that was exactly what was supposed to happen. Now, what they're saying to the court at the trial, which was a bad faith trial, which again was never pled, and they admit that in their brief, they never pled bad faith. They brought a breach of contract claim and then flipped that around to say, well, we knew, and there's undisputed. At the time of the settlement, they knew they needed the company's consent.
Let's go back to this meeting. Is it, because you focused fairly narrowly on that, is it your position that if Mr. Campagna had been sitting in that meeting with Impresa and they got down to the settlement for the 271 or the writing off of the 270, if Campagna had simply picked up the phone and called the insurer, that would have taken care of this whole case?
Absolutely, and they admitted they knew they needed to do that. Let's look at the other side, because you're as knowledgeable as anybody is on the question of duty to defend and the obligation of the insured to cooperate, particularly in a sophisticated insurance arrangement. If that opportunity to settle had slipped by, wouldn't your company have been yelling and screaming about failure to cooperate because you only had $1 million policy and you were facing a multi-million-dollar claim in a foreign court? No. First of all, we're not sure about this $10 million claim, which they compromised for a waiver of an accounts receivable for 3% of the value of it. But assuming there was this $10 million claim. No, absolutely not. Because, again, they knew they had to get consent. When they were at that meeting, they called the CFO of Besco in Jacksonville and got his permission to do it. They could have just as easily called Isco and gotten his permission. They admitted, the head of Besco admitted at trial, he knew he needed consent for the settlement. This is all undisputed facts. The problem here was exactly what we said in our initial brief. They took an ordinary breach of contract claim and at trial morphed it into a bad faith cause of action. Bad faith was never pled. They weren't allowed to try a bad faith claim because they hadn't established coverage.
Bad faith claim in a context that's different from what I'm thinking of. I mean, how is they were just seeking coverage under the policy. They weren't seeking a bad faith. When I think of that, I think of you failed to settle within the policy limits, and now we're going after you for something in excess of the policy limits. That's a bad faith claim. But this was just a claim for coverage under the policy, wasn't it?
This was a claim for coverage under the policy, and what they argued to the court was...
How is it a bad faith?
Well, this is what they told the judge, and this is what the judge accepted. And we think erroneously, you breached the duty of good faith by negligent claims handling, and that entitled us to voluntarily settle the case, and therefore there's no violation of the voluntary payments provision. That's what the court found. The court never even really addressed coverage.
Well, that's not an unpled claim, though, is it? That's part and parcel of what the entire declaratory judgment action was about. I mean,
Well,
that was the whole point of the case. It's not you talk about an unpled bad faith claim as if somebody was putting your company on the hook for an excess of the policy limits without telling you they were going to do that. Here, the whole essence of this DAC action was for coverage, right?
Right.
And that was the theory. I mean, everybody understood that from the beginning.
And this is the problem. This is a third-party claim. In order to bring a third-party claim for bad faith, you have to have an excess judgment. Not an issue in this case. So how are they going to get to that bad faith that has stopped us from relying on our voluntary payments provision? They got to that estoppel and waiver argument, which wasn't proper to consider even then, by saying...
Why is this a third-party claim? I see that appears throughout your...
This is... one of the cases, and I forgot years ago, said this is a first-party, third-party claim. It's a third-party claim because what's at issue is third-party litigation.
But
It's not a
true
first-party
third party
claim.
couldn't even bring the DEC action. They would be stuck with the... I mean, although the facts are a little bit different, why isn't this just a run-of-the-mill declaratory judgment action to establish that there was a breach of the obligation to defend?
Well, if we looked at it as a first-party claim, which I think is what Your Honor is referring to, then clearly there's no question this is a breach of Blanchard, Vest, Doe, all of the cases that say you have to have something. If you're going to bring bad faith, first you have to prove coverage. They did it. They flipped it around here. What they did is they found bad faith, stopping us from denying coverage, never addressed the real coverage issues, which were two. The real coverage issues were there damages they were legally obligated to pay, something the court never looked at, and something Besco put on zero evidence about, zero evidence that they were legally obligated to pay. The second coverage issue was, does the violation, the undisputed violation of the voluntary payments provision, provide that there is no coverage? Those were the two coverage questions. They're not even addressed in those judgments.
But I don't think there was undisputed that there was a violation of the voluntary. It wasn't undisputed, was it?
Yes, absolutely. Absolutely, it was totally undisputed. There was a violation. What they argued at trial was we're entitled to violate it because of your bad faith claims handling. That's not Florida law. Florida law says there's three ways.
It wasn't their bad faith claims handling, was it? It was their failure to provide us a defense. I mean, that was their position. You failed to provide us a defense.
No. Respectfully, no. It's absolutely, and it's pled. That was pled. Failure, negligent claims handling was pled in the complaint, and what was tried was negligence claims handling, not even so much about the investigation and the independent adjuster, because they didn't know anything about that until, years later, that there was some letter that had recommended an independent adjuster. Besco complained about the fact that there was not any direct communication, and this is what the record shows, between ACE and Hyen, EGE. That's what their complaint was about. And they said that negligence, lack of communication to settle this claim, which at that point in time, they didn't even know there was a claim, it was a potential claim, was what the bad faith was. Here, the real problem is they've settled without consent, and the trial court has created new law. There's only three ways you can settle. One, there's been an unequivocal denial of coverage. Two, there's been an outright refusal to defend.
Isn't that what the trial found? Isn't that what the trial court found? I mean, stripping all the flowery language, I mean, the trial court, rightly or wrongly, said you didn't provide them a defense, and therefore they get to settle. I mean, isn't that the essence of what the trial court found?
No, what he found was negligent, bad faith claims handling, not a denial of a defense. And that's why, I know it seems kind of simple, I went back to the policy which says we have the right and duty to defend a suit. We may investigate a claim. And now that's not just a semantic distinction. Because when you look at Doe and all the cases that the appellee relies on, there are cases where there was a defense duty triggered. The only case that doesn't involve an outright denial of coverage followed by a settlement of their cases is the Cutrale Citrus case. And that case, I will just tell you flat out, is wrong. It uses legal principles that is picked out of the air and just said, well, this case doesn't apply because you had notice of 2 other lawsuits, and it's not a collusive settlement, so you're free to settle. That is contrary to every Florida Supreme Court case and Florida State Court case, respectfully. The Thai court case, there was a complete denial of coverage, then a settlement. Even Village of Gulf, there was a complete denial of coverage followed by a settlement. That's not what happened here. There was never denial of coverage.
You're saying the duty to defend was never triggered because no lawsuit was filed?
Correct. What was triggered was their ability to undertake an investigation, and I'm out of time. That was the duty that was triggered. And there's no case in Florida, not even Cutrale, that supports that as a way of avoiding coverage.
Ms. Creed.
Okay, please the court. Rebecca Creed on behalf of Appellee Besco. This was not a typical commercial general liability policy, not a typical claim arising under that policy. ACE recognized from the outset, from the time it first got notice of this claim, that the claim was complicated, the damages were complex, the cause of the damages were complex, the claim could potentially accrue at $100,000 a day for 45 days. It was the estimated time to repair the turbine, and the cost to repair was $250,000. So from the outset, ACE knew that this was a very serious, complex claim, and with that knowledge, it undertook a duty to investigate the claim.
So am I incorrect that it was the trial court found there was a breach of the duty to defend?
That is correct. A breach of the duty to defend.
That is correct. But I'm incorrect, or
I'm
that's
sorry.
what the trial court found?
The trial court found, essentially, yes, that there was a breach of the duty to defend and the breach of a duty to investigate the claim. And that was a duty that ACE undertook. Although under the policy language it says we may investigate any claim, the insurer affirmatively undertook that duty to investigate. That reservation of rights letter is not a form letter. It specifically, as I just stated, all those facts related to the seriousness of the claim, the potential for damages, all of those are set forth in that reservation of rights letter. And with that information, the insurance company affirmatively states to Besco, we will investigate this claim. The insurance company then goes on to represent to Besco. It will hire its own expert because this is such a complex matter. It determined that it should hire its own expert, again, because of the complexity, but yet ACE never followed through and never hired an expert, but didn't tell Besco that it had not hired the expert. So we do allege that there was a failure to communicate with the insured. It appeared from all the evidence presented by Besco to the trial court that from the outset ACE was preparing its coverage defenses. While it hired an independent adjuster, that adjuster set out and essentially made a coverage analysis, which was beyond his scope. It appeared that all ACE was doing was preparing its coverage defenses rather than affirmatively going out and investigating the claim and adjusting the claim. This is not a claim for bad faith. As you have recognized, this is not a claim for an excess judgment. It's not a claim for damages under the statute or common law of bad faith. It is a declaratory judgment action asking the court to find coverage under the policy. The duty to investigate arose under the language of the policy. Under the policy language, the insured has a duty to provide timely notice of the claim.
I thought I understood this case, but maybe I don't. What exactly gave your client the right to voluntarily settle this case without the insurance company's defense or consent?
The insurance company's refusal to defend and to investigate and defend the claim.
Separate those out.
Okay.
Counsel told us that the duty to defend is only triggered when a lawsuit is filed. Agree or disagree?
Disagree. Based on the language of the policy, the duty to defend is not limited just to a suit. And particularly when, as here, the insurer takes that step of representing that it will investigate and defend a claim, it then has a duty to do so in good faith. Under the policy language, the duties in the event of an occurrence, claim, or suit. The insured has an obligation to see to it that the insurance company receives notice of the claim, but then has an obligation, the insured has an obligation to cooperate with the insurer in the investigation, settlement, or defense of the claim or suit. The insurance company then represents that it will pay expenses with respect to any claim or suit we defend, and including reasonable expenses incurred by the insured. In addition to the language of the policy, there is case law. The Village of Gulf case recognizes that the insurer's duty arises not only to defend, but also to investigate a claim, and specifically provides that the estoppel, the insurance company can be estopped by its conduct related to pre-suit conduct. In other words, the insurance company in that case had not timely and properly investigated a claim which prejudiced the insured, and the Village of Gulf Court looked to that pre-suit conduct to find that there was estoppel. There was not...
Is there anything in the record to tell us why the Besco person who went to this meeting and made this settlement, in my view, clearly to appease their favorite customer, or one of their big customers, why he or she didn't pick up the phone and call the insurance company and say, hey, we got this great deal?
No, the evidence was that, first, Besco did not know that Hana, the electrical power plant, was going to come up with this multi-million-dollar demand in March. I
mean, isn't it a case where somebody just comes up with, you know, I guess a colorable but somewhat outlandish threat, and the company just caved on that? They make one phone call to the CFO. I mean, isn't that what happened in this case?
Respectfully, I would disagree because, of all the information we had from the outset of how seriously Hana was treating this claim, the demands they had made for the $100,000 a day in damages, for the $250,000 in repair costs. It was a very complicated problem. Given that Besco had set out to investigate the cause of the turbine's failure, but was not adjusting the claim, there was testimony that Besco's president relied on ACE's assurance that it would investigate the claim to handle that aspect. So when Besco showed up in the Dominican Republic on March 15th, it had initially planned to be there to negotiate as far as what it was owed, its payments for work it had performed on this, including work on the damaged turbine. So Besco did not know ahead of time that it would be faced with this demand. As I understand it, it was then presented with this multi-million-dollar claim, and not only a claim that Hana just cooked up in a PowerPoint, but also evidence from an independent, another contractor that suggested that Besco was at fault.
Did at the time of that meeting, I mean, counsel referred us to 4 independent experts, all of who said that Besco wasn't responsible for the damage or the turbine failure or whatever you want to call it. Was that information that Besco had at that point, or was that still held only by the insurance company?
That's information that Besco had, because, again, remember that ACE never hired its own expert to determine the cause.
Besco goes to a meeting armed with 4 expert opinions and is confronted with one expert opinion, and it's reasonable for them to settle at that point?
Yes, it is reasonable. Well, first, even, I think, under the best of circumstances, Besco's reports, I think, still recognize that there was some complex issues as to fault. And while Besco believed it wasn't at fault, I'm not sure its experts' reports were conclusive as to that issue. They're then presented with evidence from Hana that does suggest that Besco may be at fault. And as ACE has itself recognized, there could have been more than one reason for the turbine failure. So while Besco is in this meeting in the Dominican Republic, faced with these millions of dollars of damages, this other information and other expert information showing that it could have been at fault, it's threatened with a multi-million-dollar suit in the Dominican Republic. And basically, if you don't come back to us by 2 o'clock this afternoon with something that we deem agreeable, satisfactory, we will sue you tomorrow in the Dominican Republic. And so faced with that, to settle it for $270,000 in the face of a $10 to $12 million claim is reasonable. particularly under the facts and circumstances of this case. Again, the duty to defend arises not only under the policy but also under the case law. The insurance company breached that duty to defend and duty to investigate, and as the trial court found, essentially left Besco to fend for itself. It abandoned the insured to the claimant. Now, interestingly, ACE now says, oh, it was so clear that Besco was not at fault, but yet at the time, it certainly recognized the seriousness and complexity of the claims and recommended that it hire its own expert. Again, the independent adjuster didn't, in fact, independently adjust the claim, but counseled ACE on how to avoid coverage. And in the face of all that, ACE determined it would adopt this wait-and-see attitude. Counsels argued what harm could there be essentially from adopting the wait-and-see attitude as of March 4th, but at that point they'd already lost much of their window to investigate the turbine failure.
What is the competent substantial evidence you would point us to that would support the trial court's finding, some kind of an implicit finding because I never saw the word specifically, that ACE breached its duty to defend?
The evidence that I'm outlining here that ACE had a duty to investigate and defend, and that ACE breached that duty by not affirmatively going out to investigate, not hiring its own expert, not attempting to adjust the claim, but instead leaving the insured to fend for itself, and again, not communicating all of this to the insured. Once ACE determined it wouldn't hire an expert, these letters that were going back and forth between ESCO and ACE were not disclosed to the insured. So,
what significance, if any, would you have us give to the fact that after the meeting occurred that Mr. ESCO knew was going to happen, he didn't follow up, didn't, as I understand the record at least, close the file?
correct.
After not hearing anything?
I do believe that that's consistent with ACE's pattern of behavior in this case, which was we think we don't have any duty. In this case, we're not informing the insured that we don't think there's coverage. We're just going to sit back and see what happens. No news is good news. But we're not undertaking any affirmative duty to investigate and defend this claim as we had promised the insured that we would. And again, the independent adjuster is not independently adjusting the claim. He's letting the insured fend for itself and deal with the claimant. And as you pointed out, the claims adjuster, along with the claims representative, decided on their own a year later to close the file without payment, without communicating that to Besco. I would point out, I also believe, and it's evident from the transcript and also the trial court's judgments, that the trial court was bothered by the fact that ACE did not present competent substantial evidence to refute Besco's claims. Besco's employees testified, its engineers and its representatives, and the witness for ACE was a senior claims handler who had not had any personal involvement in this claim, but had just sat down to review the claims file. And I do believe, if you read the transcript, it's evident that the trial court was troubled by that lack of competent substantial evidence on the part of ACE to refute these claims. I would add that this is not a case in which the trial court relied on the doctrine of waiver or estoppel to create coverage. It's clear that there was coverage under the policy. The trial court found coverage for the property damages. The trial court found that these damages were not excluded under the year work provision, and ACE has not contested that finding on appeal. The trial court was entitled to rely on the insurer's conduct to find estoppel as far as in terms of preventing a forfeiture under the policy, and that's what this voluntary payment provision was used as by ACE, was an attempt to forfeit Besco's right otherwise to coverage that clearly existed under this policy for property damage that was paid. This is also not a case in which the insured entered into some collusive agreement, Koblenz-type agreement, and agreed not to be sued. This was a case where Besco actually paid those damages to Hana for the property damages related to the turbine. And with all of these facts, respectfully...
They expended money out of pocket or just
They
wrote
agreed
off?
to a write-off, but that was money that they were entitled to recover. They had performed work and they were owed that. So it's not a case, again, where Besco didn't agree to have $1 million judgment entered against it with some understanding that Hana would not pursue that judgment against Besco, but would instead pursue it against ACE. This is not a Koblenz type of situation. There was actually money out of pocket, money that Besco paid for the property damages. There is coverage under the policy, as the trial court found, and there cannot be an effort by ACE to rely on that voluntary payment provision to avoid its duty to cover under the policy.
I understand people use declaratory judgment suits policies to interpret insurance policies, but usually to save the time and expense of some greater litigation that would otherwise occur. Why was it done here? Why wouldn't you just file a suit on the insurance policy? I'm puzzled by that.
I don't know, unless maybe they thought it was a preemptive strike as far as filing it to get in first and have it to be the plaintiff in a declaratory judgment action. I'm not sure. Respectfully, we ask that the court affirm. Thank you.
Thank you. We'll allow you a minute to rebut. Yes, ma'am.
Pages 10 through 12 of the partial declaratory judgment are the findings. There's not a breach of duty of defend. Breach of duty to defend is mentioned nowhere in either one of the judgments. It's a breach of an investigation, that you didn't possibly handle the claim properly. And again, the write-off, the wait and see, the independent expert, Besco knew nothing about, because it was reflected in internal communication, which does not have to be sent to the insured, and they haven't cited a single case about that. Besco knew nothing about that until after they filed suit. So all of this is after the fact posturing in order to create coverage when they knew they entered into the voluntary settlement without following Florida law. They did not get an unequivocal denial of coverage. Everyone admitted there was never a denial of coverage. They did not have a breach of a duty to defend. It was investigated properly in a reasonable investigation, which is all that Boston Old Colony requires. And in faced with 2 reservation of rights letters, they remained silent. They didn't reject them, criticize them, say anything different, and that's in clear violation of Florida law. They were not entitled to settle.
10 minutes recess. We'll reconvene at about 10:20.